topic. We're here to talk about what's wrong with immigration in the states. And as an introduction, before we turn to our very distinguished speakers, I want to play for you a clip.
We had to decide whether we were going north or south to get into California. My friend decided it would be best to go south to avoid the big snowstorm up north. But south would take us through Arizona. I really didn't want to go through Arizona. I got more and more nervous. I felt paralyzed. My friend kept asking me what my problem was. Finally, I told him. I'm undocumented. I came to the United States when I was 3 with my family, and Arizona had just passed a law that gave police officers the authority to check people's immigration status. If we got stopped in Arizona, I could be detained and deported. My friend is white. He comes from a really privileged upper-class background. He attended a private high school, then Santa Clara University with me. I went on scholarship. Politically, he sees things a little differently than I do. We've had our disagreements. He was quiet for a while. Then he barraged me with questions. I answered the best I could. Silence again. Then he told me about his grandfather, how he hadn't been able to find work in Ireland, so he decided to hop on a fishing boat and get off in New York. He worked as a janitor without citizenship. Now his son, my friend's father, is a high-ranking bank executive. The whole time through Arizona, my friend drove like 50 miles an hour. He didn't even want to change lanes. He told me he wasn't going to lose his best friend. He wasn't going to let that happen. The immigration debate became real to my friend in the car that day. We had a very different conversation than the one politicians are having right now. The minute actual undocumented immigrants are included, the conversation always changes. Now I'm completely open about my status. I'm still afraid. Conversations don't always go well, and it's always a risk. But as long as I remain in the shadows, I will never really get to know you, and you'll never really know me. With a perspective, this is Jose Arriola.
Our first speaker, Tony West, is the Assistant Attorney General for the Justice Department's largest litigating division, the Civil Division. This, ladies and gentlemen, is the man who is kept up at night with the responsibility of not only challenging the Arizona statute that's talked about in this clip, but also with the task of trying to resolve the constitutionality of health care reform, litigation, of habeas petitions brought by Guantanamo Bay detainees, and the government's response to the Deepwater Horizon oil spill. So we wish him the best of luck with that. Although Google, indisputably the oracle of our modern age, has a somewhat different message for him. If you type in Tony West, just a few entries below his Justice Department bio is a link to sillylittledreamer.com. When you hear the short form version of his resume, you'd want to be a dreamer too. Mr. West first served as at the Justice Department a year after graduating from law school as the Special Assistant to the Deputy Attorney General. And then he went on to serve as the Assistant United States Attorney in the Northern District of California, as a Special Assistant Attorney General for the California Attorney General, as a litigation partner at Morrison & Foerster, before returning as a presidential appointee in this administration to the Justice Department. And of course, oh yes, he's a graduate of the Harvard College and Stanford Law School, where they had the very good sense to elect him as president of the Law Review. I now turn over the podium to Mr. West.
Thank you so much for that very kind introduction, Jenny, and good morning to all of you. It's good to be here. Let me first say some thank yous to Koji Fukumura for inviting me here, to President-elect Laurel Bellows, and to Ron Marmer, who's the chair of this litigation section. So much of what you do is so important to those of us who are litigators and who really rely on the good work that you and the good guidance that you give to so many of us in our profession. And let me just say a word about this very distinguished panel that you will hear from this morning, because I have the good pleasure of actually knowing each one. Attorney General Mark Shurtleff from the state of Utah, I've gotten to know over the last year as we have worked together very collaboratively talking about Utah's immigration statutes. We may be on opposite sides of the V, but I'm very thankful for his friendship and his good guidance and discussion and dialogue that we've had over the last year. Cecilia Wong, who is the director of the ACLU Immigrants' Rights Project, who is not only a skilled advocate but also a friend of mine from the Bay Area. She has done so much to advance the cause of immigrants' rights and to protect immigrants' rights. Professor David Martin, who I had the pleasure of working with when he was Deputy General Counsel of the Department of Homeland Security. And we miss your wise counsel in D.C., David, but I have a feeling that you're enjoying being back at the University of Virginia Law School. And, of course, Jeannie Rhee, who will be moderating the panel and who I was very fortunate to be able to count Jeannie as a colleague while she was at the Office of Legal Counsel at the Department of Justice. You know, a lot of people talk in Washington, D.C., but I will tell you that hers was a voice that all of us listened to, and we really do miss your counsel still. So it's really a pleasure to be here this morning and to be with this very distinguished group and to have the opportunity to give you an overview of the Justice Department's litigation efforts involving the several state immigration statutes that have been passed over the last 2 years. Because I think in many ways there is no better proof than the existence of these state statutes that comprehensive immigration reform is long overdue. People are understandably frustrated with our broken immigration system. And so many states have turned to these statutes as a form of self-help. The problem with that approach, of course, is that our immigration challenges, they aren't confined to the borders of a handful of states. They are national in scope, and they require a comprehensive and national response. Because as we're beginning to see, a piecemeal, state-by-state approach that creates a patchwork of immigration laws, that only invites and creates more problems than it solves. So by way of introduction to this morning's panel discussion, let me give you a quick overview of the 4 cases that the Justice Department has pending throughout the country in this area. The first lawsuit that we filed, of course, was against the state of Arizona, Arizona's SB 1070, which those sponsors said was intended to create attrition through enforcement. It created new immigration crimes that didn't exist under federal law. It required the police to verify a person's citizenship whenever they had reasonable suspicion that that person was in this country unlawfully. It provided for the warrantless arrests of undocumented individuals in various circumstances. And something we hadn't seen before, it authorized a private right of action against law enforcement officials who failed to fully enforce the provisions of SB 1070. Now, in district court, we were successful in obtaining a preliminary injunction on most of the provisions that we challenged. That has been affirmed by the Ninth Circuit, and of course, as you know, the Supreme Court has recently agreed to hear the case, and so we will be looking forward to that argument. The second case in which we challenged one of these laws was in Alabama HB 56. That law was even more expansive than Arizona's SB 1070. It was designed to affect virtually every aspect of an unauthorized immigrant's daily life, from employment to housing, from education to transportation, to entering and enforcing contracts. And that case was argued in district court. In fact, Cecilia argued that case on behalf of her clients when we were there. It was taken up, appealed. It's in the 11th Circuit, and it's scheduled for oral argument on March 1st. And while we have achieved partial success in enjoining some of the provisions of that statute, we seek complete vindication of the federal interest there. Alabama is the only state where an immigration law such as this has gone into effect in some way, shape, or form. We recently also brought suit in South Carolina against that Act number 69. It, too, creates new immigration crimes regarding the transportation and harboring of undocumented individuals. It, too, has a registration provision. And like the stop provisions in the Arizona law, it mandates a status check during any lawful stop if there is reasonable suspicion that a person that has been stopped is in this country unlawfully. Now, we were successful just in the last 2 weeks of obtaining a preliminary injunction against South Carolina's law, and no appeal at this point has been filed from the preliminary injunction that the district court entered. And finally, we have filed a complaint against Utah to challenge its HB 497, which is one of 3 immigration laws that state has recently passed. And like the other statutes, HB 497 also creates new immigration crimes. It provides for mandatory and discretionary status verification of arrestees, and it permits, in certain circumstances, the warrantless arrest of undocumented individuals. An oral argument on the department's and the private party's separate motions for preliminary injunction that will be heard by the district court next month. So we have 4 states, 4 lawsuits, and as head of the civil division, as you might imagine, I'm involved in a lot of cases and a lot of litigation in federal courts around the country. But these cases are particularly important because they implicate legal issues of constitutional dimension. Now, these are questions about the respective authority of the federal government and the states. These are questions that are as old as the Union itself. They implicate strongly held beliefs about who we are as a nation and what it means to be an American. And they implicate practical concerns about how the states and the federal government will use scarce resources to address the difficult challenges that are posed by illegal immigration. And all of these laws, all of them run afoul of an important federal principle, preemption, which we'll talk about in a moment. But I think importantly, these laws are not identical. Each one reflects the unique dynamic of immigration and the immigration debate that is occurring and developing in these different states. Each one reflects regional priorities, regional concerns, regional prescriptions. Indeed, one of the key challenges that's posed by having individual immigration solutions forged locally is that they reflect very different and often conflicting approaches to what is, at its core, a national problem. Because as long as we have been a republic, we've had to wrestle with this fundamental question of who can and cannot enter the country. We are, as the President and the Attorney General have often said, a nation of immigrants. This is how we define ourselves. It's a part of our proud and rich heritage. And yet we are also a nation of laws. That, too, is a part of our heritage. And that dual reality, being a nation of immigrants and a nation of laws, that means that this immigration issue stirs very deep emotions. It carries with it significant national and international implications. And it carries results that can be very, very real for our families and for our communities. And all of this, I think, puts a premium on our ability to address the immigration question as one nation, not as a patchwork of individual states. We must speak with one voice, not 50. And that principle is really the foundation for all of the 4 lawsuits that we have filed, in which we argue that these state immigration laws are constitutionally preempted because it is the federal government and not the states that is vested with the primary authority and responsibility in immigration matters. So when it comes to regulating who enters the United States or who is removed or the conditions by which those who have entered may remain, only the federal government can do that. And while the Supreme Court has said that states may adopt laws that have an incidental effect on immigrants, when it comes to establishing the consequences for unlawful presence or criminalizing certain civil immigration violations, only the federal government may do that. And when it comes to enacting laws that reflect the various immigration or foreign policy goals that the President or Congress have set, only the federal government may do that. Because when a state acts to set its own immigration policy, it necessarily limits the federal government's authority, the federal government's ability, and really flexibility to set national immigration policy and to determine how best to use limited federal immigration resources. And that, in our view, is not constitutionally permissible. Now, that's not to say that states aren't valuable partners in immigration enforcement. Far from it. In fact, every day we are working closely with state and local law enforcement, with state and local governments to enforce our immigration laws, to curb illegal immigration, to halt drug and human trafficking. But these laws are not about cooperation. And while these laws are not identical, each one attempts to varying degrees to create its own immigration policy that interferes with, not support, federal immigration law enforcement efforts. And it's that attempt to replace the federal with the state, that is prohibited by the Constitution. One voice, not 50. And while these legal principles, I think, are rightly front and center in our lawsuits challenging these state laws, our concerns about these state immigration laws are far from purely legal. Real-world, detrimental, often unintended consequences can flow from these laws, and I think the Alabama experience is instructive here. My colleague, Civil Rights Assistant Attorney General Tom Perez, and I recently traveled to Alabama, and we heard firsthand accounts of children being kept out of school by fearful parents, school officials who told us of the precipitous drop of Latino students enrolling in school this past September, utility companies who denied or discontinued heat, water, or electricity, citing their concerns about violating the contracting provisions of Alabama's law, landlords who evicted immigrants and their families as fall and winter approached. The consequences of these laws are very real indeed, and that concerns us deeply. There's one more point I'd like to make before handing it off to the panel, and that is, before we filed the lawsuits in these 4 states, we engaged these states because the decision to sue a state is not something that we take lightly. So we followed a long-standing Department of Justice policy that counsels that before we file a lawsuit against a state, we should do everything we can, really, make every effort to resolve those disputes short of litigation. So both Tom Perez and I have spent a lot of time together on the road these past 2 years, traveling to each of these states where we've met with state officials, sheriffs, police chiefs, community members, business leaders, state attorneys general, state legislators. We've listened to their arguments. We've spent time considering their concerns. We've analyzed their positions. And those discussions were extremely helpful because they were not uniform. I mean, what was interesting is we heard many concerns voiced by those who would be charged with implementing these state laws about how difficult it would be to do so, about how difficult it would be to implement these laws in a way that didn't run afoul of civil rights or other concerns. And while the discussions that we had with these stakeholders ultimately did not result in our averting any legal challenges, I think this dialogue is important, and it's an important dialogue that continues to this day. It's important because that conversation has to be part of this national dialogue on what the shape and manner of immigration reform is going to look like in this country. And so simply because we have filed a lawsuit, that doesn't end the conversation. I do think it's part of the conversation. They're discussions that must be had not only in courtrooms around this country or in lawyers' offices, but in state houses and in classrooms and around dinner tables across this nation. And it's a discussion that we will have right now in this room with all of our panelists. So thank you so much for having me here. It's good to be with you this morning.
AAG West already introduced our very distinguished panelists, but just by point of reference, this is David Martin, Cecilia Wang, Mark Shurtleff. And without any further ado, let's start with first principles. AG Shurtleff, do states have inherent power where they believe that the federal government is not doing a good enough job to step in and tee up enforcement of federal laws?
Well, thank you. Let me just first give a quick thank you to Tony West and the Justice Department. I had a chance to introduce Attorney General Holder yesterday in Utah at our Martin Luther King Commission Human Rights luncheon. And I said what I will say again and again, that of all the attorneys general I've worked with in my 12 years as a state attorney general, this administration has been the most open, the most willing to talk and work together. And by the way, we collaborate on a lot of public safety issues and other things, a lot more than we disagree on some things, and we do disagree on some things. And I appreciate all the effort they put into trying to work out our issues before they sued us. And I'm going to be very upfront as to why I think that was a mistake. But let me just say this: obviously, we all know that and believe in the separation of powers vertically between federal, state, and local governments. I'm a constitutional student. I love the federal government of this country. I recognize its roles, but I'm also very much enamored with the roles of states play in that very important nation that we have of states. I strongly support the enumerated powers of Congress, and I also very strongly support it, and for 12 years as Attorney General I've been required to protect the rights of states through the 10th Amendment, the rights of individuals in states where specific powers are not given to Congress. And we know when it comes to immigration, so-called immigration issues, that Article 1, Section 8, Clause 4 says that the federal government shall establish a uniform rule of naturalization. Who becomes citizens. That clearly is a federal role. We also recognize the role of the federal government to protect this country and to protect our borders. But when it comes to this very heated immigration debate, I constantly try to tell people they need to separate the issue of those who come here to work and those who come here to be citizens. Really, the vast majority of those who are here in this country undocumented are here because they came to work. They're not in line for citizenship. They're not trying to become citizens. They want to work, provide for their families. Because of the problems, they haven't been able to work and then go home and then come back and work again in migrant status. So what that comes down to then is this question. First of all, do the states have some role in that we are the ones being impacted by the undocumented population? We are the ones paying for education, for law enforcement, for health care, and so forth. And these people live amongst us. They're in our communities. We go to church with them. Our kids play junior jazz together. They are in our schools. This is where it is, and it's not at that federal level. So when the federal government, first of all, does it have exclusive authority in this area, and more importantly, where it's clearly abdicated its role and its responsibility? And I'm not speaking about the executive branch here. I'm talking about Congress. And I think we could even probably in court have the judge take judicial notice of the fact that Congress has failed in its responsibility when it comes to immigration and naturalization issues. They have failed to do comprehensive reform, to fix legal immigration, to take care of the issue of those who are here, and what we do with those who are here undocumented. That is a failure. And when they fail to do that, it hurts the states. States want to step up and act. Flat out, they want to act. My feeling on it is, and why we try to do something different in Utah, was that states right now are thinking the way to act is enforcement only. Tough enforcement laws where state officers step in for federal officers and start enforcing the laws and trying to deport people. To me, that's wrong. It hurts public safety in the end. It hurts our economies. I absolutely oppose what Arizona did and what other states are doing. So in Utah, when there's headlong rush like other states toward, we got to do something, well, everybody's doing enforcement laws, let's do ours. We said, let's do something different, because 1070 is not the answer. It's not going to work. We had to say something more than just say no, so we came up with, we'll maybe talk about some of the other things with regard to guest worker permits and so forth. But I want to make it very clear that we took the Arizona law, the judge's ruling, and we very specifically took out the objectionable things like reasonable suspicion and mandates penalties that people can sue law enforcement and cities and counties if they're not enforcing these immigration laws. We took that all out. And yes, do we do warrantless arrests? Yes, we do warrantless arrests every single day of U.S. citizens based on probable cause. Our law is based on probable cause, not reasonable suspicion that a crime, a felony, or a serious misdemeanor has occurred, substantially different, and I think we'll prevail, frankly.
Well, Cecilia, you've sued the state of Utah.
We have.
And why is that? In light of the AG's position here that Utah is different and that Utah has a role, and a permissible one, to try to do something about the immigration problem.
Well, we brought suit against the state of Utah many months ago, and we're pleased that the Justice Department came in as well more recently. The reason is that while I genuinely believe that Mark and others in Utah were trying to find a solution and trying to come up with a comprehensive way to deal with immigration, the way the federal government should, and I agree with you on that. The problem is that it was done through 4 separate enactments. And the one against which we've brought suit, HB 497, is an enforcement-only piece. And that is the only one that was going to go into effect fairly soon after enactment, while the guest worker legislation has an effective date of 2013, and frankly, I believe is illusory because it hinges on and is contingent on federal approval of a state guest worker program, which would be unprecedented. There's simply no federal mechanism to do that. So what I'd like to do is focus on the enforcement piece, which is the law that we've challenged. I have to disagree with my friend Mark because the HB 497 provisions, from a civil libertarian point of view, in some ways is worse than the provisions in SB 1070. And the reason is that it requires everyone who is stopped by an officer in Utah to present ID, and it further gives an enormous amount of discretion to individual officers either to disregard someone's identification if they have some suspicion that the person is undocumented, which we believe will lead to racial profiling problems. And more fundamentally, it really signals a sea change in the way that we as Americans look at our constitutional rights. We, as a general matter, expect to be able to walk down the street or drive down the street for passengers in cars, not to have to show ID, not to have to confront a police officer who's demanding to know whether we have a right to be in the country. And to us, that is offensive to the Constitution, not only from a preemption perspective, but from a Fourth Amendment perspective and from a perspective of equal protection.
So, David, in your role at DHS, with the immigration portfolio on your plate, how do you referee a dispute on the ground like this? Because certainly both the federal Constitution and federal statutes contemplate at least some level of cooperation on the part of states in assisting in the enforcement of immigration laws. So how do you determine when they've gone too far, when enough is enough?
Well, this ties back into your first question about first principles, about states having inherent power to enforce. And a lot of times the question is posed in that way, but that makes it pretty much of a black and white question. The power to enforce involves a lot of different steps. And it has been a pattern for many decades, and certainly reinforced by statutes enacted mainly in 1996, that there is certainly a role for cooperation between the federal government and the states in various parts of that process, particularly in early stages. Some people talk about an inherent state power to enforce. It was reinforced by an OLC opinion, Jeannie's old office, but before Jeannie was there, it was adopted in 2002. They took a pretty expansive role and talked about inherent state powers to enforce the laws, not just the criminal laws relating to immigration, but also the civil laws that would result in deportation rather than a criminal prosecution. There's been a lot of misunderstanding about that. That opinion was issued in 2002. That was the same year as the torture memos. It wasn't really a great year for OLC memos. I think that 2002 opinion was erroneous. But people, in talking about a power to enforce, nobody believes that a state government has the authority to go ahead and set up its own immigration courts, actually try out someone's status. The most they're talking about is initial identification and some cooperation with the federal government. So it becomes a rather tricky question. The federal government has wanted to and has tried to shape its position in this litigation in a way to preserve a good role for cooperation with the states in those early stages. And the main place where that occurs is in cooperating with the states in a variety of ways to focus on individuals who are caught up in the criminal justice system, to prioritize the removal of people who are not just here illegally and working, but who are also involved in criminal activity. There's been controversies over secure communities and others. We can get into that later if you wish. But the main thing is that there is a role for the states, but the federal government ultimately must establish the priorities and the policies. That's the way in which the Arizona case was argued. Those are themes that have been continued by the federal government in its litigation stance elsewhere. The cooperation is appropriate, but cooperation on the federal government's terms. And ultimately, the Ninth Circuit ruled in that way. They read one of those 1996 enactments, which said you don't have to have a state doesn't have to have a formal agreement with the federal government in order to cooperate in the investigation, apprehension, detention, and removal of people who are here unlawfully. But the Ninth Circuit said cooperate means cooperate on the federal government's terms, not on the state's terms. And that has been the problem with many of these enactments. It tries to set up a set of priorities and a set of steps that can create a hostile environment for people who are here perfectly lawfully. So that's the way in which I would like to see it come back to more of a situation where it's understood that there is a cooperative role, but a cooperative role on the federal government's terms, not on the state government's terms. And it's important to do that in that way. It's not just a matter, many of the state laws seem to be premised on the notion that federal immigration policy has only one main objective, maximum enforcement. In fact, our immigration laws are quite complex. We also want to facilitate lawful migration. We want to integrate people who are here lawfully and are on the process of joining our society. We want to make it a hospitable location for foreign business people to come here. That can't happen if some of the law enforcement community broadly in the United States has a really intense focus on asking difficult questions about anybody whenever there's reasonable suspicion to go forward. That's the reason why the federal government takes that position. It's a subtle difference, but I think it's a very important one.
Well, let's play devil's advocate. Without any of these state statutes, police officer under existing law has every permission and authority to walk up to an individual and ask about immigration status. And so what is it about these statutes that makes them unlawful when the baseline under current existing law gives police authority to the states to do lots of things in the day-to-day?
Sure. I think that what's going on today goes far beyond the bounds of what officers can do in the ordinary course. So we know that there's case law, for example, the Mueller versus Mena case, which was expanded to traffic stops in Arizona versus Johnson, and the Wren doctrine as well, that lets officers engage in consensual encounters, ask questions of people during traffic stops. These laws go far beyond that in a couple of ways. First, even as to traffic stops, they create a comprehensive state system for enforcement. And as David mentioned, they have other provisions built into them. For example, in Arizona, sections 5 and 6 of the law give anyone in Arizona, a private citizen, the right to sue an agency that they believe is not enforcing the law to the maximum extent possible. And so officers are going to be required, essentially and in effect, to dig into immigration status, to leave no stone unturned during a traffic stop, to ask everyone in the car. We had a conversation with a family that was very upset in Arizona after passage of the law because they were pulled over. There was a father with his young daughter. She was 8 or 9 years old. And there were 2 other 8 or 9-year-old girls in the car. They were all Latina. And the police officer asked for the children's ID. I think that's the kind of thing that these laws are encouraging. The second way these laws go far beyond what officers can do in the ordinary course is that if you look at a law like Alabama's, which in many ways is the opposite had the opposite motivating intent from Utah, the laws have all kinds of provisions that are unprecedented and mean-spirited and unconstitutional. For example, we've heard how Alabama passed a provision that chills the right of children to attend K through 12 public schools. That includes U.S.-born, U.S. citizen children who may have a parent or another family member, someone in the house, who's undocumented. Because the law requires proof of both the child's nationality and the parent's nationality, we're going to see it's a real effort to turn back Plyler versus Doe. And Alabama has also enacted two provisions that essentially create civil death for undocumented immigrants and those who may contract with them. Those provisions effectively void any contract entered into where the parties knew that one of the parties was an undocumented immigrant. And it also makes any state entity or local entity check people's immigration status before engaging in a so-called business transaction, which essentially has been interpreted by many state entities to cover anything like getting a driver's license, paying your permit for your mobile home, et cetera. So we actually had to bring a separate lawsuit in addition to our facial challenge to the law to try to enjoin the state revenue board from forcing people to show ID when paying their annual permit for their mobile homes. So poor working folks who live in mobile homes in Alabama were at risk of being evicted. This is the sort of thing that's happening. Alabama has specifically said, the legislature said, we want to make Alabama so inhospitable to immigrants that they will self-deport. And as David said, that's not the aim of the federal system. There are many different considerations that go into the federal government's decision whether to deport someone. And Alabama is trying to override that comprehensive system Congress has enacted.
Well, A.G. Shurtleff, let's turn to the Utah enforcement provisions. Under existing law, are you asking the state officers to do anything above and beyond what they're already entitled to do?
No, absolutely not, and I appreciate it. I don't want to get to like a tit for tat on how our laws specifically differ from others, but we were very careful to make sure that what we did was not provide officer duty responsibility to stop everyone. We certainly don't do that. You know, and guess what? City cops, deputy sheriffs, state troopers, they do not want to enforce federal law. They don't want to be looking for people's immigration status. We're very busy doing our jobs under state law, thank you very much. We understand the federal government says, look, on our terms, you can go 287G, you can get this special permission from us, except now they don't give the permission anymore. And so we're still left with this issue. So we don't want to do it. And in Utah, the legislature listened to our police officers. In Arizona, Alabama, they didn't listen to their cops. They didn't care. You're going to do it anyway. So what do we do in Utah? What is our law? It's only if you are stopped on probable cause, not reasonable suspicion, a probable cause that you committed a felony crime or a serious misdemeanor offense, a Class A misdemeanor. Only in those occasions where you're going to be arrested, you're being probable cause arrested for those crimes, that we ask for ID. We ask it for everybody. That's what we do. How are you going to identify who they are? It's only then where if you cannot produce that identification, that they're required to then inquire into the immigration status of the person. Do we have people in Utah who are there illegally to just commit crimes? Absolutely. I mean, there are those in this country who come here not to work, not to become citizens, but to commit crimes. And we're trying to ferret those out and deal with those people because guess what? The very first victims are other undocumented aliens, are other members of minority communities, and they need to feel safe and protected, that we're there to protect them from the real bad guys. And that's what we're trying to do and find a balance where states can do this in the absence of federal government doing more about it. We want the federal government to take care of this responsibility. We don't want it in the state. But here's why I object to the fact that they end up suing us and we keep getting lumped in as the four terrible states who have put forth enforcement only. And that is states, and you have a chart here to show where people are going. Are they going to are they trying to be less tough? Each state seems to be trying to trump the next one.
Can we pull up that chart?
And each one's trying to be tougher than the other. In Utah, we did something substantially different And yet, the message the federal government sends, and I told Tony this, the day he called me and said, we're going to sue you, I said, you're sending a bad message. You're sending a message that no matter what the states do, in the absence of federal government action and congressional action, you're going to sue us. And ACLU is going to sue us. So we might as, states are just going to say, legislators say, well, why don't we just do it enforcement only? And Utah tried to do something different, still bottom of litigation.
David, let's just get to brass tacks. I mean, what would the world look like in terms of the federal government's ability to enforce criminal laws and to go after really bad, violent offenders if you didn't have states' cooperation and assistance in assisting on that front?
Well, I think it would be problematic. I gather you're talking about the assistance that feeds in ultimately to an immigration response, not just a criminal law response. And that has clearly been a part of the overall position. Cooperation with the states is important. Identifying people at some point in the state criminal justice system as well as federal criminal justice system who are here without status, those should be our priorities for applying limited removal resources. And the effort has really been underway for many years to try to find more efficient ways to focus the effort along those lines. So I think it's important to look for ways to do that. Exact details about how any particular state does it need to be worked out, need to be looked at very carefully. Along the way, I mentioned it before, I think I'll say something more about it. There's been a public controversy over the so-called Secure Communities program that actually is designed, I think that program has not been understood properly. The federal government hasn't done a great job in explaining it. That's a matter of looking at getting the right kind of information to the immigration authorities, federal immigration authorities, based on people, not just who are stopped, not who are witnesses, not who make a complaint to the police, but people who are actually arrested, fingerprinted, and booked. So someone has made a determination, not on an immigration violation usually, it's on a regular offense that's part of the law enforcement officer's regular jurisdiction, found probable cause to arrest them. The fingerprints are taken and sent to the FBI. Under Secure Communities, they're checked with the immigration authorities, and the immigration authorities then make a decision, determine whether the person's here unlawfully, make a decision about whether to go forward with some sort of immigration enforcement after the criminal justice process has run its course. I think that's the right way. Now, with the current kind of difficult situation we have, with 10 to 11 million people who are in the country, residing here without authorization, to focus our resources on that population and their efforts that are underway to try to do that. Keeping that kind of cooperation on the federal government's terms going is very important. But that's a kind of interim measure. I think as we're all in agreement, the ultimate solution has to come at the federal level. It does have to come through legislation. It is possible to think of a very different situation. 10 years from now, we should be in a situation where we can enforce the laws effectively, the immigration laws, where not only that, enforcement isn't really the objective, it's the observance of the law, respect for the law. We need to develop a different kind of ethic, a kind of norm of compliance with that. But I don't think we can get there unless we do something about the people who have really long roots in this country that were sunk during a period where the laws haven't worked very well. So to do that, it needs a kind of legalization program. Congress is the one that has to do that. It has to happen at the federal level. Things don't look very good right now. It makes for easy negative sound bites and demagoguing in a campaign. But at some point, we may be able to get there. Utah had a very interesting process, political process, for working with a wide range of groups and interests in the community to develop the Utah law. I hope that could be a kind of model someday for what we'll do at the federal level. And I'll just say one more word. What a lot of people haven't noticed along the way is that actually the current situation is such that the flows are way down. Apprehension levels by the Border Patrol are at levels we haven't seen since the early 1970s. Not as many people are coming. There are a number of changes in Mexico that account for that as well. At some point, it may take many years. At some point, I think there may be enough people who will say, okay, we are... the new arrivals have slowed down. Let's take care of the old mess, and then let's have a really serious system where lots of people, including immigration advocates, support the idea that, yes, people ought to comply with the law, and we should have a more rigorous enforcement from that point on.
I want to turn to the audience. If there are folks who want to ask our panelists questions in the remaining 15 or so minutes that we have on the presentation.
While we're waiting, I feel like I've just been angry up here. I'm not. I'm frustrated that we're in litigation, and I'm not really angry. But I do want to make it clear that what we're trying to do with regard to our other laws that are probably going to be challenged in the next couple of years, and that is with this guest worker provision. Because I hope you understand, in Utah, for example, for a decade now, we've had in-state tuition for the children of undocumented aliens. We think it's very important to give kids hope, because I got 70% of my gang members in Utah are Latinos and only 50% of the population, and they're trying to pull these kids and tell them, white Utah saying your parents are criminal, you can't succeed, you can't even go to college, pay the same tuition that your high school classmates are paying, that you graduated with, so come join our gang, we'll take care. I mean, there's reasons why we do that. In Utah, we've had a driver's privilege card because these people in our communities, we want them to know our laws, we want them documented and have insurance. So we do these things. And so when it came to guest worker status, our attitude is they're there, they're working. Right now they have to work with stolen or made up Social Security numbers. We want to stop that. Let's bring them out of the darkness. We're not making them citizens. That's the role of the federal government. But just like they're here driving, they're here working, let's bring them out of the darkness. Let's recognize they're here. Let's protect their families and let them work. Let them work with this privilege card. We'll do a background check to make sure they're not criminals. We'll even collect taxes and send them to the federal government when they're ready. But until the federal government can actually make this thing work with the people who are here to work, we want to do something about it. And the reason why we put it off, obviously, is because we want the federal government and recognize their role in this and giving some kind of okay or thumbs up to us allowing us to do this. And frankly, it'll help the federal government. Because with all the deportations, and they've done more than anybody else in the past, any other administration, they're still only deporting, 4 or 5% of the population? They clearly do not have the resources to deport or go after the vast majority of people who are here. So our thing is that you should focus your limited resources on the bad guys. You should focus on employers who are paying under the table, who are making people work injured, who are not paying them and threatening to deport them. Here we're going to say in Utah, we're going to pay competitive wage. We're going to let people work. People come in, these are people, criminal background checks. They're good people. They're members of our community. You don't have to worry about those, federal government. We're doing you a favor. Take them off your list. Because we're looking out for people who are otherwise productive, otherwise law-abiding citizens or members of our community.
Well, Cecilia, turning to you.
Yeah, I think there's a question out there.
A member of the audience asked, I was interested in the DREAM Act and what you thought about it and what you think might happen with it. Are we going to have an election before people will come to the table about the DREAM Act? It seems pretty moderate to me.
Yeah, I think David may have thoughts about this too, or Mark. I think that was one of the hugest disappointments that in the current climate in Washington, D.C., even the DREAM Act couldn't be pushed through. And I hope that...
Cecilia, for everybody in the audience, can you just give
Sure.
2 words on what the DREAM Act is?
Well, the DREAM Act is a shorthand for, it could cover a lot of different kinds of proposals, but essentially it's to give some kind of path to legalization for people who came here as very young children, undocumented, who were brought in by their parents, like the young man we saw in the beginning of the panel, who in many cases don't even know that they're undocumented until they get a little older. You probably all saw the case of Jose Antonio Vargas, who's the Filipino immigrant who came out. He was a very successful journalist. And is now stuck in this limbo. So there are people who are culturally American and are just have no legal status, and in many cases have no ties back in the old country and don't even speak the language.
Well, all of the current congressional efforts seem to require both a carrot and a stick, because as David articulated, you can't really address the problem until you have at least some stemming of the migration of undocumented coming into the country because of all of the resource constraints. And question about, again, if you need to have a carrot and a stick, how do you go about doing this in a humanitarian and humane way?
Let me just say, on my comments on DREAM Act, which I strongly support. In fact, in Utah, we passed our in-state tuition hopefully in the understanding that then the DREAM Act would pass, because we get kids who can now pay in-state tuition because they graduate from high school in Utah, but then once they get a degree and they're still undocumented, how do they work? And there's no pathway through like a DREAM Act. And it breaks my heart, frankly, that members of my party and presidential candidates in my party can't even support something as sound and as a carrot, and it's not even a carrot, it's not a draw, it's for kids who are currently here, to take care of kids who are truly U.S. citizens in every aspect except on paper. I mean, a couple weeks ago I had a chance to go to a local high school. There's a group called Latinos in Action. There are probably 60 kids in that classroom. I didn't know their legal status, but I talked to them. They're all speaking almost perfect English. So what does Latinos in Action mean? Oh, it means we love America, and we want to do something to serve. These are great kids, and then I asked the teacher after, he said 90% of those kids are undocumented. Their parents are undocumented, but they're here, they're part of this, and they want a chance to succeed. They want to go to college, they want to help. Those who serve in our military should have a pathway. And so I don't know why we can't do that. Even people like Orrin Hatch, who years ago used to work very well across the aisle and was a supporter of the DREAM Act. And now, because of the current climate, and he's facing a tough re-election in Utah from the right wing of the party, he's worried that he didn't even vote it out. That's the problem with, frankly, with my party, is that there's too many people worrying about the loud, shrill, anti-immigration voice that they think that's the base of our party, and it's not. And in Utah, we're going to prove it, because we did something that put a target on every single Republican who supported these efforts. They're all facing challenges by right-wing extremists, anti-immigration forces. And we're going to prove coming up here in the next 2 months, as we go through conventions, that all the Republicans who stepped out to do the right thing, truly the right thing, and not what they thought the shrill party was calling for, shrill part of that party, it's going to be a message to Congress. You don't have to pander to these groups. You can do what's right. And we hope that message will spread to other states and nationally eventually, so that they can at least pass something like the DREAM Act.
I hope that's the case. I think it's really important if we could have that kind of an electoral experience, because it does seem to be in the primaries where this primarily comes out. And again, it's an issue that's subject to easy sound bites, but most people, even some who have taken pretty extreme positions, once they come into contact with some members of their community they discover are here in an unauthorized way, I've encountered many situations in which they begin to take a different view. Polling tends to show that a substantial majority of the public supports some kind of legalization program. It could be on many different terms to get beyond that. But the intense feeling is not there. The intense feeling is for people who think of this in a very abstract way and make that kind of approach. I do remember early in the Obama administration, I went around with Secretary Napolitano, some initial calls on a number of congressional offices to talk about the prospects of immigration reform, looking to put together what we thought then was a real chance for a bipartisan coalition, building on the bipartisan coalition that had been there in 2005 to 2007. And there was support, but so many of them spoke of the time when some of those bills were on the floor in 2006 and 2007. They got more phone calls, nasty, ugly, oppositional phone calls, than they'd gotten on any other issue. Again, it's not representative, I don't think, of the majority feeling, but it's part of what makes this such a difficult issue. So the DREAM Act may be someplace where we can break through if it comes up shortly after an election, when we're as far from the next election as possible. Maybe if there's some different experience in some of the electoral campaigns and primaries that come up during this coming season. In 1996, there was a little bit of a change. There was an opening. In 1996, there had been some very tough legislation. When President Clinton got reelected, some leaders of the Republican Party thought, whoa, wait a minute, and Clinton obtained broad support in the Latino community. There was some support for legislation. There was actually something that was passed in 1997 that really was an amnesty with strong Republican support called NACARA for some Central Americans. Maybe we'll see some of that dynamic happening, but we do need some dramatic evidence, I think, on the electoral front that some people can still prevail even though they take a more reasonable or moderate middle road position.
You get the last word, but to the audience, the call to action.
Yeah, I hope Mark's right, but I'm worried. I don't think the evidence so far is good. Mitt Romney made a big announcement that Chris Kobach, speaking of right-wing extreme anti-immigrant activists, had endorsed him, the apparent front runner right now. And just to put it in a little bit of context, again, speaking about the activists who are behind these extreme measures, the map that we've put up here shows what happened in the space between Arizona's enactment of SB 1070 and now. So basically all the part-time state legislatures were in session, started going into session around this time last year. There were 14 states, by our count, who had something you could call an SB 1070 copycat, so some kind of omnibus or comprehensive immigration law. Many of those states took a wait-and-see approach. They want to see how all this litigation plays out before they step in. In the 6 states where the ACLU has filed suit, the laws in all of those states have at least been put on hold temporarily. As in Utah, there's no decision on the merits yet, but the court issued a TRO against the entire law. In the other states, we've gotten a PI, a preliminary injunction, against at least parts of those laws. And if we can turn to the second map, the one that's labeled Projecting 2012, this is a little bit out of date. This was projected back in the beginning of December, and we have a little bit more intel now. But these are the states that we think pose a significant threat of introducing legislation this term. So all eyes are going to be on the Supreme Court in U.S. versus Arizona. These laws didn't start with SB 1070. The ACLU and coalition partners started tackling the state and local effort to get into the business of immigration enforcement as early as, say, 2006 in this most recent round, when Chris Kobach and other extremists started pushing out model ordinances to cities like Hazleton, Pennsylvania, Valley Park, Missouri, and Farmers Branch, Texas. Those cases we've litigated successfully so far. But there's a real danger here, I think, to put it into context. The legal issue, the doctrinal issue at the court this term is going to be limited to federal preemption and limited to the 4 provisions of the Arizona law that are up at the court. But as we look across this landscape, we see states getting into the business of regulating the K through 12 education of immigrant families' kids, including U.S. citizens. We see all kinds of measures that are out there that differ in many important ways, as Tony and Mark have both illustrated. Each state has its own idea about what needs to be done. Some of them are coming from a place of wanting to exclude immigrants. Some of them, well, one of them so far, has come from a place of trying to figure out some comprehensive way of dealing with it. But the fallout goes far beyond immigrants. Whatever you think about illegal immigration or immigration policy, if you care about the U.S. Constitution, we have to be very concerned about the fallout of these laws. We have to be concerned about the fact that law enforcement officials, including Chris Burbank, the chief of the Salt Lake City Police Department, George Gascon, currently the district attorney of San Francisco, where I live, and formerly the chief in Mesa, Arizona, which is a suburb of Phoenix, have come out and said, when you tell police officers or sheriff's deputies to go out and ferret out undocumented immigrants, the only way they can do that, unless they're in a border region and see someone surreptitiously crossing the border, is to rely on racial stereotypes, to rely on stereotypes about people who speak English with a foreign accent. And that is going to lead to serious and systematic civil rights violations. And that's why the ACLU and other civil rights organizations have challenged these laws not just on preemption grounds, but on Fourth Amendment grounds, First Amendment grounds, and others. So we're going to be in a lot of trouble as a country if this patchwork really develops, not just because we need uniformity in immigration policy, but because we have American values about living in a free society.
On that note, please thank the panelists.
Well said. Good job.